5 of At Your Service with Haber and Martinez. I'm Haber, and as you can see, Martinez is not here today. But this fine-looking gentleman off to my left is Gary Kollin. I'll introduce you and tell you a little bit more about him in a moment. First, I want you to know what our show is about today. Today's episode has been entitled, Don't Get Mad, Get Even, Police Civil Liability. And the idea of the show basically comes from the fact that over my 31 years, I have been asked more times than I can recall about suing police. Whether it's right or wrong, many persons who get arrested have complaints. Some are merited, some are not merited, some are actionable, some are not actionable. But I am a guy who stays in his own lane. I don't do civil rights litigation. I don't file civil lawsuits. I certainly don't practice civil law in federal court. So it's outside of my wheelhouse. I have referred some of these cases to lawyers in the past, lawyers just like Mr. Kollin, because their expertise is in this area. But Mr. Kollin does more than just that. And to give you a little bit of background, Gary's been practicing law for forever. He started in 1979, and he began his career with the Broward County Public Defender's Office. After serving as an assistant public defender, he hopped over to the dark side and spent a period of time serving as an assistant state attorney, also with Broward County. So he kind of worked both sides of the fence and very wisely learned under two very seasoned offices how to litigate cases from very different perspectives. After finishing with the state attorney's office, Gary went and became the field counsel Medicaid fraud control unit director of the Attorney General's office. He spent several years there before opening up his own private practice, wherein he did criminal defense work, wherein he does a good deal of criminal appeals work to date, and wherein he really honed his skills as a civil rights litigator, focusing in the area of police civil liability. His firm specializes in police misconduct cases, and by that, I mean cases of police abuse, false arrest, excessive force, illegal searches, seizures, and also malicious prosecution cases. He also does other types of law, including including class action lawsuits, where he has actually gone after the Broward County court system and the Broward County Sheriff's Office as an entity for what we believe, or he believes to have been, civil rights violations, successfully, I might add. He's also argued in front of the United States Supreme Court, and I am very, very pleased and happy to have Gary here to share his experiences and expertise with the audience, and so that maybe we'll all walk away with a better understanding of, did the police screw up, and if the police did screw up, is it actionable, and if it is actionable, what's it worth, and if it's worth something, how do I go about getting it, and what's it going to cost me, et cetera, et cetera. With that said, Gary, thank you so much for being here today.
Well, thank you. It's my pleasure to be here, and thank you for that wonderful introduction there. I'm humbled. And Michael, I know of your expertise in the area of criminal defense, and I want to compliment you on that. And thank you for that I can be here and help share my knowledge with the people listening in about police misconduct work, litigation, and so they understand many of the misunderstandings also about the cases.
Tell us a little bit about that. Give us a little starting point.
Well, in order to have a false arrest case, you first have to have an arrest without probable cause.
And I'm going to go off for 1 second so that the folks understand, probable cause is a legal term. It's legally defined, and it is something that is required for an arrest to be made, whether it's by a police officer in the moment on the roadside, let's say, or whether it's the standard that they have to reach in order to get a warrant from a judge authorizing arrest. Either way, that's the legal standard. So what I think Gary's pointing out at the first point is they have to fall below that standard. And you guys need to understand that that standard of probable cause is a very different standard than the burden of proof beyond a reasonable doubt in a criminal courtroom. So a police officer can arrest you and you can be acquitted. The jury could find you not guilty. The state attorney could null pros or no action the charges, or they could subsequently dismiss them, or the court could throw it out, or the evidence could be suppressed. None of that necessarily means the probable cause for the arrest did not exist.
Well, Michael, you've gotten really into the nut of, or the center of what I was going to explain, because many times there is probable cause for making an arrest, but maybe they can't prove the case for many different reasons. They don't have the witnesses. The prosecution doesn't think that there's sufficient evidence that the jury would find somebody guilty. There may be other issues that may be involved in regard to the case. Like many times, officers may have been fired for their in between the cases, and they'll get the case dismissed. However, if probable cause exists, regardless of the dismissal, there won't be, you can't sue for false arrest. Now, you could sue for perhaps many other things involved in the case, like malicious prosecution. I'll explain that in a second. Excessive force. There are other causes of action you could sue for. Those are state causes of action, and that's where there are violations of state law. And there's also federal causes of action. Many people hear about them and call them 1983 actions or violation of the civil rights. And sometimes you can sue for both. If I can sue in federal court, I want to sue in federal court. We have finer judges. We have litigation that moves a lot quicker than in state court. Usually you'll get to disposition or a trial within 1 year, while in state court it takes 2 or 3 years before you even get there. And so you want to do that. Now, let me explain to you what malicious prosecution is. Often that follows.
Let me ask you one question before you get into malicious prosecution. Reference your comment about preferring to be in federal court, and I know that the primary reason you indicated was the time factor and the experience level of the judges. Is it also fair to say that there may be some component with regards to the idea that in state court, many of these judges are going to have interaction with their colleagues and with these same police officers, and they're also subject to re-election? And so you have, some considerations with state court judges. As lawyers, we look at things and say, you know what, this judge is going to be running again for office in a year or in 5 years or whatever it is. And, federal judges are appointed for life. They could basically, shy of getting impeached, they could do damn near anything they want without fear of reprisal.
Michael, that is one of the other points that I intended to present, was that, and we often call that being hometown. Like, for instance, for instance, let's say I'm filing suit in Martin County. It's a Martin County arrest. Well, if you file suit in state court, it's going to be in Martin County with Martin County jurors, who Martin County voters, Martin County taxpayers. So they may think that their county is going to be having to pay out a lot of money. While in federal court, if you filed in federal court, you filed in a federal court that encompasses not only Martin County, but Indian River County, St. Lucie County, and it's a much broader area, and you have a much more varied number of jurors. Now, the other part is that you talked about is many times these police officers have contact or in relations with the judges. Sometimes these judges who do civil matters in state court, they also do criminal matters, and they've had encounters with the police officers. Some counties, the judges do both civil and criminal, so they're having encounters with the same police officers. But you reminded me of one of the most important things that came about. For instance, in Broward County, the bailiffs, the ones who take care of the jury, are Broward Sheriff's deputies. They wear Broward Sheriff's uniforms. And if you have a Broward Sheriff case, they're the same people who are taking care of you that are going to court. Now, in state court, they come in with their vests. There's no reason to have the vest in state court. I understand why police officers have vests. They come with their vests. They come in with their pepper spray. They come in with their asps, those long sticks they can hit people. They come in with their guns, and now they look in a manner that it creates a different impression in front of the jury. In federal court, they can't do that. They can come in uniform. They can't come with their weapons. They can't come with their guns. or they dress up in suits. But in federal court, the only ones who are allowed to possess firearms or weapons are the marshals and the court security officers, and those you don't see those exposed. So the jurors, you want to have jurors not in being supervised by the same people they may have to vote against, and that goes to one of the other reasons that I wanted to be there. Also,
is there? Let me ask
let me
you
just
this.
let me just bring one
Sure,
more thing.
sure.
Now, a lot of these attorneys are attorneys in the same county or jurisdiction in which you have the cases. Now, these attorneys have been there for years. They may know the judges before they became judges, after they became judges, and judges do fundraisers. And judges get money from these larger defense firms that represent the police agencies.
Mm-hmm.
Now, I'm not saying a judge is going to vote one way or the other just because the judge got some money, but psychologically, somewhere in the back of the mind, the judge knows that.
That actually brings up another question that I have with regards to money. And again, I'm just speaking specifically to the idea of litigation forum, state versus federal, right? Not on the end game, but is there a higher chance for recovery in federal court as opposed to the caps in state court for the same exact conduct?
You can. Well, we don't. I'm not going to say it's state court versus federal court with regard to the caps. It's the state claims that have a cap of $200,000 for one person, $300,000 for the total incident involved, and because of that, sometimes these police departments or sheriff's office want to take the risk because they know it isn't going to be as high as they might. However, in federal court, you have no cap. I'm sorry, in federal claims, you have no cap.
Okay, so if it's a state claim,
you can file the state. I'm sorry. You can file the lawsuit either for including federal claims in state court, but you go with the problems we just discussed of having the state court judges. But in federal claims, there's no limitation on the amount of money somebody could give. And also in federal claims, there's attorney's fees that could be awarded to the plaintiff, the person who's suing, the person who's aggrieved. And in that particular case, those attorney's fees could be astronomical, hundreds of hours an attorney has to put in preparing for the case. Now, the attorney's only going to get a contingency fee from the client, but sometimes with awarding of state of attorney's fees, the client gets 100%, nothing less than what the amount was awarded by the jury, and the attorney gets separate funds equivalent or greater than what would it be on a contingency fee case. So it's a very good bargaining tool if the police agency thinks that they're going to lose the case, even for a small amount, because they're going to have to pay for a large amount in attorney's fees.
So when you're talking about, I just want to be clear, you can file whatever your situation is, and I know we haven't really identified all the different areas, but there are different state court causes of action under the umbrella of, let's just call it, police misconduct cases. And there are also causes of action in federal court. And they may be, some of them could be the same cause under state law or federal law, and then there are different causes under each, correct? Or am I mistaking you?
No, you are 100%
Okay.
correct. Michael, I think you should get into this area. You've got a complete understanding of it.
Thank you. I'm getting my master's right now, Professor. So apart from that, then the other end of that is that if you're in state court and you pursue state court claims, you're capped on state court caps.
And in federal court, the same thing.
And in federal court, you're capped on the state court claims to the state court max, but you're not capped on the federal court claims.
And there is a way that you can file federal claims in state court. You can do that, but I don't do that.
Right. For the reasons you've stated.
I'm going to federal court.
So, But let's just say hypothetically, if somebody did file both state and federal claims in state court, they'd be capped on the state claim. Would they also be capped on the federal and state court, or is that still open-ended in
It's
state?
still open-ended.
Okay. And there's no conflict where I know certainly the federal courts can handle both issues of state and federal law, but how is it that state court judges have authority to deal with federal statutes?
It's the statute permits it, and Congress has passed a law, and the courts have upheld that state courts can consider federal civil rights violations.
So I guess the first takeaway for the audience here is, if you think that you have a viable police misconduct claim, you better be talking to a lawyer like Gary, who really understands all of the dynamics of where to even start, because your starting point is going to be very important. If you file this in state court, you're limiting yourself potentially in some ways. And if you file it in federal court, you may be limiting yourself in other ways. I don't know. I guess each case, probably your case is very similar to when you were a prosecutor or a public defender, or in your capacity as a private defense lawyer. You see, as I do, where it can depend on the facts and the circumstances. Maybe it works better in one place or another just because of the who, what, why, when, where, and how of it.
This is true. Very true.
So apart from the false arrest, which you briefly talked about, and just to recap again, false arrest means that an officer made the calculus that he employed to determine that probable cause exists as a matter of law fails, right?
That's correct.
That's what you need in order to go forward for a false arrest. So if it turns out that for whatever reason you beat the case, but the probable cause existed, you don't have a false arrest case. What other types of cases might we have other than false arrest?
Well, I told you, battery, where the officer uses excessive force, is the state court claim. And in federal court, it's a violation of your Fourth Amendment rights for excessive force. And so you can get both.
Okay.
Another one, which is a First Amendment violation. I don't know, Mike, if you've watched any of these First Amendment auditors. They're incredible people. They go around and they film, let's say, prisons from the outside, or a police parking lot, or things of that, which is totally legal because it's being photographed from or videoed from a place where you can stand, where you can see your own eyes. And many times they get handcuffed and their cameras are taken away, or they're arrested and they come up with bogus charges like, let's say, disorderly conduct or obstruction, where they won't turn over their ID. If there's no at least reasonable suspicion that you committed a crime, even though you're not arrested, they do not have the right to take your identification in Florida, or demand that you identify yourself. I have a case just like that now. May I share that with you?
Yeah. Oh, please, please.
Okay. I have a client who just contacted me. He was in a public park. And while most public parks have hours posted on there where they're closed, this one didn't. So he's in the public park. He's allowed to be in there. There are other people that were in there after, well, the park across the street closed at 7 p.m., but this one didn't have the proper signs. So he was in there. The police officers came up to him and they asked him for his identification. He refused. I didn't do anything wrong. There's no reason why you have my identification. He didn't have a camera out, but he did say that. Well, they anyway arrested him for trespassing in the park. And that trespass was without probable cause, because he did not violate any statute or ordinance.
So they couldn't have creatively written him up for some kind of loitering and prowling type charge and then justified their suspicion that way?
Well, they could. We don't see many loitering and prowling anymore. It's usually a trespass or a obstruction where they don't turn over identification, or things like that.
So I guess into this category that we're talking about now, probably one of the more common things that the audience might be able to relate to, which we see with some reasonable frequency, is, the officer pulls you over, and as he's walking up to the car, you get your cell phone out, put the video on, and now you're rolling tape on him. And he says, "What are you doing with your phone?" And you say, "I'm recording this encounter, officer." And you happen to be in front of, Officer Unfriendly, who takes exception to that and either smacks the phone out of your hand or grabs it from you or orders you to turn it off. Would that be one of these types of situations?
Sure. Those situations, with the fact of whether you go litigate such a case, you have to compute in what are the value of the damages that could be awarded, what are the hours.
Get to that
That's
later.
That's an attorney decision. You don't take every case that something happened on, because some of them are the violations are of such a minimal level that you don't. Now, I had a client that had he was held in handcuffs for 20 minutes. They detained him for 20 minutes, and we got close to 6 figures for a settlement in that case for 20 minutes in handcuffs. He wasn't taken to the jail. He wasn't booked. None of that ever occurred. In fact, they never even got his identification from him.
Can I sign up for that plan like twice a year?
Well, I was thinking about that too. Why don't you go become a First Amendment auditor, and perhaps you can accomplish that important thing. One of the other areas I practice in, and it's close to that, is you go to Walmart, and on your way out, they want to see your receipt. Okay, everybody has. You just came from the cash register. You are not legally obligated to show them your receipt unless they have at least what we call reasonable suspicion that let's say one of the security people saw you put something, look like you put something in your pocket, or you kept a piece of clothing, but simply because you're leaving the store, you cannot be required to show your receipt. So then the police come along sometimes and they arrest you for not showing, show your receipt, things of that nature. Or let's say you pay for your goods and you're with your spouse or somebody else, or the other person paid for the goods, and the other person's going to go get the car and bring it back to the front. And while that happens, I've known many times I don't even know what I did with my receipts. And the police come along and you're arrested for shoplifting because you can't produce the receipt. Well, you had no obligation to produce it. I just want to do one caveat, one thing here. Warehouse stores where you have memberships,
right, like
Costco, BJ's, and Sam's, in your contract, you have agreed to allow them to check your receipts in doing that. And so therefore you have to show it to them. That's why you're obligated to do that.
I was just going to ask you that, because obviously I go through that at Costco all the time, but sometimes I do, they do that occasionally at like Home Depot, and it's maddening because first of all, it takes 20 minutes just to get through the checkout counter, even if nobody's in line, because they're so incompetent. And then they have the nerve and audacity to stop you at the door, and it's very maddening. But your remedy there, what you're talking about, and I just want to be clear for the audience, there's whether it's a loss prevention employee, I don't care if it's a security guard with a, little officer security, Paul Mart, mall cop, whatever, they're not law enforcement. Those guys are not subject to the Constitution. You can't sue them for civil rights violations, can you?
No, but you can sue them under state law. You can sue them for false arrest. And if they continue the false arrest case, if it gets an information filed against you and that continues, you could also sue for malicious prosecution. And the point is, regarding that, there is no limitation on the amount of money you can get.
But you're still limited by the amount of reasonable damages for the conduct.
Of course, but also you are going against Walmart. You're suing Walmart, not the individual. And that's how the lawsuit is written. So people, when they see that, they don't feel, there's a lot of animus, or people don't like a lot of these big corporations when they're doing these type of things. I read recently, though, something to be warning people about is that um, there's been some problems with the Walmart self-checkout, and people are accidentally not putting things, or things are not being scanned, and they have been stopping people and arresting them for that. So um, that's something that people should be aware of in regard to using the self scanners. Whoops.
Interesting. So I mean, we get an awful lot of those, and I didn't realize that there was this is another great pro tip. Um, I didn't know that there was an action against a private entity under this umbrella for that type of conduct. But again, it's also good to know the caveat with regards to the fact that you have a membership. So that's good. I'm just noticing on our ticker information, Gary, it looks like they left out a digit on your phone number.
Oh, you're right. I didn't notice that.
5472399.
9.
All right.
All
So
nines.
there's 4 9s on there. It just
Yeah,
happens.
I got very lucky in picking out my phone number. 723-9999.
And for some reason, my information isn't scrolling next to yours as it should. But be that as it may, it's not about my and your ticker information. It's about providing the audience with viable information and pro tips. I want to talk a little bit more about use of force, because you started to go there. And one of the questions that I get with great frequency primarily on my YouTube channel, I have a video on this, and it draws an awful lot of contention. And it's usually from people who just, believe what they believe and want to say what they want to say and don't want to accept the reality of it. But I think it's probably a very fitting thing to hit up here. And that is use of force by a civilian against a law enforcement officer. So we know there's a difference between resisting arrest without violence, meaning, look, you just don't let the officers put the handcuffs on you or you try and run away from him, versus resisting arrest with violence, where you actually commit some sort of act. Now, if you are obviously just sua sponte violent with the police, like a cop walks up to you and says, excuse me, sir, may I see your ID? And you just cold cock him in the face, that's one thing, because that's clearly a criminal act on multiple levels. But what if it's the opposite? What if the officer is really aggressive? What if you're in a position like some of these folks, wind up in, where officers out of the gate are overly aggressive, and you feel that you must engage in self-defense to avoid significant bodily harm or even the potential for death? Where do we fall on that continuum with regards to a citizen's ability to do that within the parameters of the law, or am I going beyond the parameters of our topic?
Well, I think if a individual feels their life is in danger, they need to use self-defense, they have to use it. And if it was reasonable force in regard to those type of things, then that would be okay. Now, let's say a police officer comes up to you and it's an illegal arrest. Okay, it's without probable cause, and they go to arrest you, and then you use that great physical force of just simply handcuffing you, and they're going to take you to jail. That's wrong. But if you pull away slightly, and that's you can, pull your arms away, that's resisting without violence, and you can resist without violence an illegal arrest, and therefore that doesn't take away from. And if they charge you resisting arrest without violence, then it's an illegal arrest. You still have a false arrest claim. But let me make it clear here: if you're arrested on more than one count, and even though there's no probable cause for one of the counts, but you're legally arrested on the other charge, or second charge, you cannot sue for false arrest. So as long as there's probable cause for a charge. And it's much more complicated to get into, but if there's a charge that the police officer didn't even know about, and that creates probable cause, you can't end up suing for that, suing for false arrest in regard to that particular charge.
So I want to be clear about the issue with the audience, and I'm trying to just look up the law real quick as we're talking. But I just want to be clear with the audience because I get, as I said, I get these questions an awful lot about an individual's ability to use force against a law enforcement officer. And we throw around terms like self-defense and stand your ground. And in Florida, you have every right to defend yourself from an imminent act of violence. In fact, you have a right to defend other people from an imminent act of violence, and you have the right to defend your property. And you certainly have the right to defend against a threat of what you believe is going to be death. But the question then becomes, what happens if you commit an act of violence against a law enforcement officer? And your claim is, no, I'm not just beating on cops because that's who I am. I was defending myself, right? So if during the course of an arrest, excessive force is being used against you or what you believe is excessive force, let's say the Tyree Nichols case. Are you familiar with that? In Memphis about 2-3 months ago, Tyree Nichols was traffic stopped by a bunch of undercover specialized units. They called them the Scorpion team, I think. And when you watch the video of this, because that's one of the beauties of body cam, or maybe it's the opposite if it doesn't work in your favor, but it's very clear that they just, were unbelievably aggressive with this guy for no apparent reason. They didn't know him. He wasn't the subject of a felony warrant. There was no chase. There was no pursuit. It was allegedly a traffic stop, and they wind up dragging the guy out of the car and ragdolling him to the ground. And the next thing you know, he's got a half a dozen, big ununiformed, plain clothes, I think, again, they called them the Scorpion unit guys on top of him. So if he is expecting that he's going to be potentially killed or paralyzed or, seriously injured, to what extent can he defend himself?
To the utmost extent, if he's got to defend himself to protect his life. If somebody's, beating you to death, you have a right to defend yourself in any way possible. Now we know in self-defense, you can't, once you've gotten allayed the harm or whatever, you can't go on. So let's say you knock out the police officer, you can't be on top of him punching his face in just like you can't do it with anything.
So that would be the same. That would be the converse of the law enforcement action, right? You still have to use that amount of force, which is reasonably necessary under the circumstances.
Correct.
So,
and sometimes it's up to lethal force.
I just want to be clear with the audience. Under no circumstances do I endorse becoming violent with law enforcement. The same way that I don't endorse being a wise ass with them or snappy with them, because you're likely to produce a violent response, or at least a response if it's not violent. The cops have an expression, I'm sure you've heard it, Gary, a million times. You might beat the rap, but you'll never beat the ride. And there's another expression that we use in the defense field called being held in contempt of cop, right? So when you start
insulting the badge.
Yeah, when you start lecturing the cop on, I know my rights and this and that, look, not the right thing to do, not the right time, not the right place, not the right person. Let the cop give you the ticket, get even. Don't get mad, like we titled this show. Don't get mad, get even. There's a time and a place to deal with it, and a person, and the person is your lawyer. So we hit false arrest, we hit excessive force.
Can we talk about statute of limitations?
First Amendment. All right, let's go to the statute of limitations.
Okay, one thing I just want to add on to what you're saying. So many times in cases, when there are videos, you hear the person going on, I'm going to sue you. I'm going to take you to court. And then it doesn't come across well in front of a jury because they're saying, oh, he antagonized the officer to do this type of thing. He set him up so he could sue. It doesn't help you. And don't think that by saying that the police officer is going to change his or her mind and not arrest you. It doesn't happen in regard to that. Michael, I know you, in all the criminal cases you have, these people say, I'm going to sue you. And it never changed the police officer's minds.
It prompts me to remind the folks of the adage that revenge is a dish best served cold. You're not going to get anywhere in the moment. You're just not. Deal with it later. And Mr. Kollin is 100% correct, because look, there's a reason that the Miranda warnings say anything that you say can and will be used against you. And that is because your words, whatever they are, can be interpreted in different ways, depending upon the prism and depending upon the context. So even if you say all the right things, they could be twisted or manipulated or put in a way or in a form where they become incriminating instead of exculpatory. So the less you say, the better. It's one of the reasons that I have my tagline, hashtag UpX2. Shut up and lawyer up. Invoke the fifth, invoke the sixth. The less you say, the less you do, the less there is to come back and bite you. Plus, it gives your lawyer a clean slate. We get to worry about the narrative and how we want the narrative to play out in a courtroom, as opposed to being married to something that we can't go back in time and change. Yay?
I agree 100%, Michael. We're on the same page. As I told you before, you have a great understanding, which carries over, which was my benefit of being the state attorney, assistant state attorney, assistant public defender. I knew how many things were being done. I knew many times what police officers said outside the courtroom or outside depositions, talking with, with directions with regard to that. And I knew where to find records in regard to things that they don't want you to find. And I knew I had contacts to do that.
It was an awful lot easier back in the day. I mean, I guess maybe in a way you could argue it either way, but I think body cam, I would assume, has had an incredible effect on these types of cases, as it does in the criminal defense arena. For instance, with a DUI case, it used to be that the officer would claim X, Y, and Z, and basically it was his word or her word against that of the accused. It was literally came down to a he said, she said, because there was no independent proof. And then all of a sudden you've got body cam. And now you can see whether or not the individual was able to touch the tip of their nose with their finger. You're able to hear the instructions and the way the officer instructed the individual, whether it was done, in military, very rapid fire fashion, or whether they actually took the time to explain it to them. Did they show them how to do it? Did they give them the benefit of the doubt? If they screwed up, were they polite and pleasant and say, maybe you didn't understand, sir, let me repeat the instruction? I mean, in other words, when you get done looking at it, you can look at your client and say, you know what? This cop really screwed up and we got something to work with. Or you can look at your client and say, look at yourself and tell me if you think you're going to do well in front of a jury with this video.
Exactly. We had talked also about getting into statute of limitations, and this is one of the things that really grip me when I hear people, because like you said, you don't do civil rights cases, you don't do false arrests, and you don't do civil cases in general. So if you have a situation with that, I know what you do, and you said it. You refer the person to a lawyer who handles that particular area. And I have faced many lawyers who say, oh, the statute of limitations doesn't start running until you're found not guilty. That's not the law. And we have cases, for instance, let's say there's a trial, and then there's an appeal, and then there's a retrial, and they're found not guilty, and all of a sudden it's 4 years down the road, and they cannot sue. In Florida, there's 2 statutes of limitations. If you're going to file those state torts, we talked about the state causes of action, like false arrest and battery, and you're going against the governmental agency, you have 3 years to send in a specific notice to the police agency, or to the town or city or whatever, the governing body. You can't sue a police department, but you send it in to the agency, noticing them with your name, date of birth, place of birth. They ask for your social security number. exemptions to doing that, and what you're going to sue over, the arrest on such and such a date in regard to that. If you don't do that, you will not be able to file suit at all, even at 4 years. If you 3 years and 1 day go by and you haven't sent in that notice, you are out of luck. But you're not out of luck on the federal claims. You have 4 years to file suit on any federal claim.
And that's 4 years from the date of the incident?
Correct.
Okay. And just another aside, because I think I have at least a modicum of understanding about this, and maybe you just touched on it and I missed it. But when you send in that notice, does that or does that not, as I believe, give the respondent, whatever the individual or entity is, they get like a 6-month period to contemplate your notice, and you can't do anything. You can't file anything until that time ticks. Is that correct?
You can't file it under state law. You can file it under federal law. Now, if they have 6 months to try and resolve the case without litigation, to see if they could settle the case.
State law.
State law. You're not required to do one under federal law. Now, there's an equivalent type of lawsuit against the federal government, which is the Federal Torts Claims Act. And what that has to be is within 2 years of the incident, you have to file a specialized notice, which requires a lot more information, telling the federal government of your intention to sue. Now, there's no statute of limitations with regard to that, even the 4-year one on those things, because you cannot sue until they respond to you in regard to that, essentially.
So there's basically, it's like a waiting period. You're giving,
correct.
The statutes contemplate a period of time for the parties to figure out whether or not they want to settle this thing, or it's going to go forward and proceed to litigation.
And those federal cases are tough cases. So let's say you're suing the FBI or the U.S. Attorney's Office for, let's say, the Southern District of Florida represents the FBI in that lawsuit. And back in Washington, they have a whole legal team in the FBI office, the General Counsel's office. And they've had these cases from around the nation all the time. So they're feeding law and assisting with the United States Attorney's Office with regard to that. So they are very tough cases.
Yeah, not to fail to mention the fact that they have an unlimited bank account and they can just print more money when they need it. or seize more money and then use that.
Correct.
Let me ask you a little bit about a subject that I get very often in my criminal practice, and I'm sure that you have gotten in yours. A lot of times you get a client or a potential client who's really hot under the collar with the cops for one reason or another, or maybe even with their probation officer. It could be anything. They feel like they were just wronged and they were mistreated. Maybe they were called names. Maybe they were harassed, be it sexually or religiously or racially or what have you. And they're so incensed that they want to file a grievance against the officer. They want to go file a formal complaint against the cop that arrested them or the probation officer that violated them. This happens with incredible frequency, understandably, not always rightfully and not always intelligently, but nonetheless, it occurs oftentimes. And what I always tell people is the same thing. Again, there's a time and a place. You may be 100% right, but normally I would say probably 999 out of 1,000 times, my advice is file nothing and say nothing. You've already got an adversary and there's no need to poke the bear and just piss them off even more and give them more reason to come at you. Do you agree with that or disagree with that? Or, I guess every lawyer has their own take. So
I think I agree in spirit, but I disagree in the sense that it has to be analyzed on a case-by-case basis. I want to take probation officers aside because the courts have granted them certain immunities from being sued, and the Department of Corrections, who supervises them, immunities. So if you're going to sue a probation officer, it's very unlikely that you'll be successful. It's like the same type of immunities judges and prosecutors that you cannot sue.
Why is that? Why do they get a carve out?
Well, the probation officers,
I mean, POs specifically.
yeah,
POs.
because one is, in some sense, they're considered officers of the court, so they fall under judicial immunity. And there's a whole line of cases where does the probation officer owe a duty to the individual probation officer or to the public in general? And they found that the probation officer owes the duty to the public in general, just like you can't sue the clerk's office.
What if things like I get common with POs I would say all the time, but regularly. So I have a client who has to go in and give a urine sample, and the PO watches, right? I mean, they always have to watch the urine sample because they have no other way to know that they're actually getting a urine sample from the person providing it. So what happens when they've got a female probationer and a male probation officer insists on watching? That's not actionable?
I've never faced that, and I would like to do the research on that particular situation. I know we have different issues with frisking, whether it's unreasonable under the situation. I have a case involving that where the police officer put her hands in my client's underwear out in the street. She used gloves, but it was totally improper against state law, federal law in regard to doing that, and it exceeded those limits. Now, that's a female on female situation, but that you can sue over that one.
Then I would assume you could sue over the other probably. But
the issue is probation officers in general.
Let me also be clear that what I said about my generic advice being don't poke the bear, don't file that cop complaint up front, that has nothing to do with, and it may actually be contradictory advice. So I usually preface it with telling people if they believe they have a complaint about the officer that they want to file a lawsuit on, they should talk to someone like you, Gary. But my advice is not considering those types of civil cases. In fact, it's irrespective of them, because again, I don't want to necessarily, I don't ever expect the officer to walk in and be the accused best friend, but I also don't need them to have multiple reasons to want to, double down on their testimony and do all in their power to secure a conviction to avoid any kind of civil liability, or even worse for some of the officers, because they're coming out of their pocket. I would assume, although you'd know better than me, but the other angle is that apart from the money issue, you've got the testimonial issue, and that can become a real problem in terms of proof in a courtroom.
Well, you're exactly right. The right to remain silent, Michael. I'm sure that whenever you have a case, you cringe when you open up the discovery and you find out your client has made a statement to the police because they did invoke the right to remain silent. And that's the same type of question that comes up when you want to know about filing a an internal affairs or professional, because you're going to require you to give a statement, and that potentially could be used against the client in the criminal case. So you don't want that to and they're tape recorded, so it's like the video, so they're all tape recorded.
And they're under oath on top of that.
Yes.
So any statement you have to give to internal affairs is going to be a sworn statement.
And the officers there they're not your buddies, okay? So they may go ahead and push the envelope. You could have an attorney present in regard to that. Now, there are cases where I've recommended to my clients to file the internal affairs, and that gives us what I call an extra deposition of the officer to find out all the things ahead of time. So later on, when he is represented by counsel in a civil lawsuit, he doesn't get the counseling there about how to answer. He might have a representative from the union, but those representatives from unions are not lawyers, and they're not looking ahead for the civil matter.
Interesting. So again, I guess another pro tip, it all boils down to case specifics. Every instance is different. Every client is different. Every arrest is different. Every arresting officer is different. And obviously they have to be looked at through the prism of their own unique facts and circumstances. Let's talk for our last couple of, well, I guess we got about 10 minutes or so left. I want to talk a little bit about compensation and attorney's fees. I would assume that we could liken, at least to a degree, civil rights lawsuits, police misconduct lawsuits as a whole, this category that we've been discussing, to kind of like personal injury cases, where a lawyer such as yourself has to make a business decision on every case, whether or not the potential recovery is viable enough and valuable enough to incur the time and expense that you have to give it and dedicate to it without being paid up front. Some PI lawyers will take partial fees from a client and partial contingency. Some are full contingency. How does it work in your arena?
Well, it comes in originally as a contingency fee case. Percentages are, I go with the standard percentages of the profession. 1/3 if it's settled before lawsuit, 40% if it's in lawsuit, and 5% additional if there's an appeal. So, but you also have, as I explained earlier, that advantage in the federal cases where they may end up having to pay that and the client gets 100%, but you're not going to get that in a settlement. You're only going to get that if you go to trial.
And win.
Of course. Well, it's me. I'm the lawyer, so I think I'm always going to win, and that is the particular situation involved. One of the things you talked about earlier, and I want to brag about, is one of my first civil rights cases where I did a class action against the Broward sheriff. And what happened was the Broward sheriff had a policy that if you were in court and you went to trial and you were found not guilty and there were no other holds against him, you had there was no legal basis to hold you in custody at all. And they could have found out about it with just a phone call. They would take the person back to jail. They have to do the strip searches that come in from the courtroom, and they have to do that. They take them up to the cell. They make them change into the uniform, and they hold them there for hours until they release them. And it's what we call FIFO, first in, first out. So if they're processing other people, you're at the end of the line, and you're not going to get out of there for hours until they finish that processing. Well, I took this to federal court for the 221 people, and the federal judge outlawed that practice.
That's awesome.
Outlawed it completely. And each of those people, now they might have been in jail for 6 months already. That's pretty terrible on the charge, but there was probable cause, and they were found not guilty. Well, each one of those people got $5,000 for the few hours they spent in jail after being there for all that other length of time. And that was a tremendous benefit to them, who are people who've been, now they have a foot up to get themselves set up in society. It took a while to get it, but the sheriff's office has done it again. And I have a case now, not a class action, but an individual they did it to. They took him back to jail.
Sounds like they're going to get slapped for that one. Did you have any role or knowledge of the back in the day when the former sheriff, I forget which one
Nick
it was,
Navarro,
when he was manufacturing crack and putting them out on the streets?
No, I had nothing to do with that. Those matters. They found that as far as the criminal cases, I think it was found as a due process violation.
Yeah, there was entrapment.
Entrapment, but that would not be a good type of thing for a police misconduct or false arrest case.
Why not?
Well, the person did obtain the cocaine. What you're saying is so there essentially was probable cause that they committed a crime, And I think that any judge would say, no, you can't have a case under those circumstances.
It's a shame because a recovery on that, they could buy some more crack. Um, what are your most realistic type of claims to pursue in this arena? What is it that you find most commonly?
I think I find most common are these detentions with or false arrests. For instance, I had a case involving the town of Medley, in which we sued them. We reached a settlement in regard to the matter, and but we had actions where we contended they entered onto the property of the person without a warrant, went into his house without a warrant, and in fact, in that video, where he is struggling to get away, not fighting like you talked about, the officer put him into a chokehold, and that was a year before George Floyd. But I'm telling you, I think any juror seeing that video would have been very upset, even though it had occurred before George Floyd.
And what, just briefly on George Floyd, any thoughts on that? I mean, not politically, just as a matter of police misconduct litigation.
I think the city of Milwaukee made a very wise decision in settling that matter for the amount of money they did. I don't know the limitations in Milwaukee, but I'm sure that the federal claims would have been astronomical along with the attorney's fees.
You know, that actually brings up one little dovetail that I just realized I didn't mention. When we were talking about statutory caps, and you said it was 200,000 per individual and 300,000 for 200 for the first individual, 300 for the incident. There is a provision in Florida law where you can get more, correct? You just need the minor little hurdle of a special session of Congress.
Well, a special session of the state legislature, signature by the governor. And
have you seen that happen?
I saw one recently, but those are usually done where there's catastrophic physical injuries, like somebody who's crippled for life in a car accident or things of that nature.
Well, what about like when somebody dies in the jail because of they were neglected, they didn't get medical treatment, or they were beaten in the jail to death by correctional staff or even by other inmates? They were not properly supervised. What about, that type of a thing?
Well, with the health services, for instance, in Broward County, the health services are private contractors. So they do not have a limitation on the lawsuit against them. So you can, if the health provider did not provide proper medical care, you can sue the health provider. Now, there are certain exceptions for suing. You cannot sue the state of Florida. You can sue municipalities, counties, other agencies, but you cannot sue state of Florida. So you can't sue the Highway Patrol. You can't sue the Department of Corrections. You can't sue.
But what about local? I mean, like, let's say it happens in Broward. The guy's in Broward County Jail, in the main jail, or he's in the Conte Center, and he gets beaten to death by corrections officers.
Well, then you have a lawsuit against the corrections officer. If it was intentional torts, something that he did intentionally, like that, then the government agency has an out saying it was not done within the scope of his employment. You could sue the individual officer involved, or if you can show that the agency knew about the propensity of that officer to do violent crimes, you could sue the agency or the Broward Sheriff's Office in that case. But each case is fact specific.
Last question I have for you. Tell the folks what it's like to argue in front of the Supreme Court of the United States.
It was a once in a lifetime experience. We see photos and everything of the court. We don't see photos, but the most amazing thing is you're just a few feet away from these justices. And they come after you with questions. They have law clerks who develop them. They read everything where you find other judges didn't. They come up with genius things, and it's amazing. And they help you out sometimes and tell you a better answer than you gave for another justice's question. It's a lifetime experience. You realize there's only 80 cases argued a year, about 160 lawyers. So I've been doing this for 43 years. We'll say 40 years as a lawyer. There's going to be, what is that? 6,400 times, 6,400. No, that's not right. But anyway, there's about 8,000 opportunities to argue in the U.S. Supreme Court during those 40 years that you're practicing law. And I got one of them. In fact, I was appointed by the court. I had represented the individual in the trial court, in the lower court, and the United States Supreme Court graciously appointed me to represent him there. And
well, they did that guy a favor because he had excellent counsel.
You know what? I recently had dinner with him, and he said the same thing to me. You were the best that I could ever have.
You know, that's the type of thing that makes the job worthwhile. One of the few things that really makes the job worthwhile.
I agree with
Gary,
you.
our time is run. I want to thank you very, very much for coming on and for sharing your knowledge and your expertise with the folks. You know, you're such a down-to-earth guy. It's hard to believe you're a Harvard guy. You know, you just seem more like...
Got my emblem on my shirt.
You seem more blue collar. You seem more blue collar than Ivy League. But I guess that's a testament to who you are and how good and effective you are at what you do.
I like to talk to the jurors with their language.
I really appreciate your coming on and sharing your time and experience with the folks. I want to remind the folks that the ticker information for your phone number was missing the last digit of 9. So if you want to reach Gary, his office phone is 954-723-9999. With that said, that's going to conclude episode number 65 of At Your Service with Haber and Martinez. We will not have a show next week. I don't believe. I'm scheduled for trial, actually retrial, in a cocaine trafficking case that the state mistried about a month ago. So hopefully we'll get 6 picked and actually get through it this time. If something happens, we will be here if the case gets continued. Otherwise, we'll see you on the 8th of May, I believe. And again, Gary, thank you so very much for your kind time, for your expertise, for your experience, and for sharing everything with the people and allowing us to be at their service.
No, thank you. It's been my pleasure and my honor.
We'll see you all soon, and we will get the links posted just as soon as the producers send it over. We'll publish everything up to YouTube and the rest of social media. Thank you all again. Wishing you a great week. Thank you again, Gary. Thank you, Miami's Communities newspapers, for all of your great work. And we'll look forward to seeing you with episode 66 coming up soon.